Welcome to Engaging Experts, the podcast that goes behind the scenes with influential attorneys. Our guests will describe their practice and expertise. Then we will go deep on various topics related to effectively using expert witnesses.
Hi, this is Russ Rosenzweig. I am the CEO and co-founder of Roundtable Group and also the host of this podcast series. We have a great guest for you today, Andy Lustigman, a partner at Olshan in New York, and our resident expert on all things related to false advertising claims. Welcome, Andy.
Good to be here, Russ. Thanks for having me.
Now, before we dive in, a quick word from our sponsor.
This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Andy, thanks for joining us today. I want to first express my gratitude to you. I'm not sure if you know this, but you were actually one of our very early clients at Roundtable Group, going all the way back to the early 2000s. So thanks for sticking with us for all these years.
Well, our pleasure. It's been a successful relationship over the years. So you guys provide excellent service and excellent selection of witnesses, very well qualified witnesses. So it's an easy choice.
Thanks for saying that. And our topic of the day is advertising law. And I want to just start by, many of our listeners are fellow business owners like me, who periodically need to engage counsel for many kinds of matters, including advertising related matters. So I want to just discuss a little bit about your background. After you graduated from the University of Michigan, which is the second best Big Ten school right after my Northwestern Wildcats, I'm really curious, why did you decide to go to law school? And when did the focus on advertising law as a specialization start?
So I originally wanted to go to law school because I had a strong interest in politics and very much wanted to work in the political arena. I was a political science major at Michigan, and I went to law school in Washington, D.C. I went to the American University Washington College of Law. And as my law career, or as schooling evolved, I sort of, had to change of focus to more of a traditional law practice. I got sort of some of the color of politics had worn away, and the interest in it, although I remained very politically active and interested, but being directly involved became less of an interest. And I took a position as an associate at a law firm in D.C. When you're going through law school, where you work your second summer is a key thing, a key place. And the firm I worked for, I found out later on that Barack Obama and I were summer associates at the same firm. He was in the Chicago office, and I was in the D.C. office. He became president, and I defend and prosecute false advertising claims. So you can see how those things turn out. In terms of going into advertising law, my father had a boutique firm focusing on advertising and marketing law. And so I always had an interest in it as a child and growing up, although my intention was not to join him. And a woman I was on law review with actually joined his practice when she graduated. She wanted to transition to Reader's Digest, going in-house at Reader's Digest. And the DC firm that I was working with was having some issues. So I decided to join my father in New York and join his boutique firm. And been practicing in the area of advertising law since 1995. And continue to practice with my father to this day, although we've merged the boutique firm into a full-service business law firm, Olshan.
Ah, amazing story, and thanks for sharing that background. And let's dive into some topics related to false advertising, because many of my fellow business owners and I periodically see, ads from competitors that seem to be false. And I want to start maybe going back to the 80s, which I think I kind of recall being the golden age of advertising. I can still fondly recall those famous commercials about garbage bags that leak and batteries that die while your daughter is playing with her favorite toy. And, I recall all manner of really boastful commercials like Crazy Eddie claiming to have the lowest price in the universe. So I'm really curious, were there a lot of false advertising lawsuits back then? And how has advertising disputes, how have they evolved since the 80s?
So maybe I could even take it back a couple of years, really, to the 70s, and it relates to a lot of the things we've been talking about. So the short answer is that there were significant, problems in advertising. A famous case would be like they would for soup. I don't remember if it's Campbell's soup or not, but to make the soup look like it had much more meat and vegetables, they put rocks underneath the beginning of the bowl. Was an example. Or someone would have two different wipers. Would put something on the glass to make one look more blurry. So there were lots of different mechanisms that were being used to manipulate product advertising, particularly in the comparative sense. I think in some respects there would be instances where there was a concern about using a competitor's product name. So you may recall seeing those ads with comparing your product to brand X.
Yes.
Or they'll say, well, we tried the leading brand and not show it as brand X.
Or the other guy.
You would see that. Yeah. But there was a significant problem with national advertising that was going on. And in part, so the typical remedy for a competing business is to file a lawsuit under what's known as the Lanham Act, which is typically thought of in the trademark context for infringing a trademark, but there's a provision that allows a competitor to sue for false representations. But overall, what was happening is that the government was very much going to step in and heavily regulate some of these advertisements that were going on and some of these manipulations and the like. And what happened was industry bandied together and said, if we don't act in terms of self-policing, we're going to find ourselves facing onerous federal regulation. And with that, they founded what's known as the National Advertising Division, or NAD, as a self-regulatory body to oversee national advertising and for competitors to have matters resolved outside of government interference. So that's sort of the origins of NAD, was because people were really taking too many liberties with respect to advertising.
Well, that's a really interesting evolution. And I want to talk more about NAD because, I'm a member, Andy, of all these various organizations of fellow fast-growing company business owners like the Young Presidents Organization and Entrepreneurs Organization, Collective 54, Provisors, and, fast forward to the present day, we all sort of regularly talk about our concerns about competitors' advertising claims. It's real in these days. And, but business owners, we really don't quite know what to do. We don't have a blueprint or a plan of action. Often we'll, call our lawyer and ask them to write a cease and desist letter. Sometimes we'll just be so upset that we'll go full bore with a Lanham Act lawsuit. I don't think any of my peers are aware that there is the National Advertising Division. So can you say a little bit more about what are the options for executives to pursue if we feel like one of our competitors is advertising falsely?
Sure. I think there's a number of options. They all have pluses and minuses, and ultimately the course of action may include multiple steps or more than one. But it's important to have a candid conversation with your client to determine what his or her goal is really with respect to the advertising. So the simplest thing that you can do is to have a well-constructed cease and desist letter, which puts the advertiser on notice as to the offending conduct and requests voluntary compliance or else. And the or else is the biggie. Are you prepared to back up your threat, or as they say, are you going to be all hat and no cattle? So, are you going to say, I'm going to do horrible things to you if you don't comply, and then you don't do them? Or do you have a mechanism to back it up? So a cease and desist letter could be backed up with a lawsuit, typically in federal court under the Lanham Act, as I mentioned before. There are benefits to bringing a Lanham Act case, and there's significant downside to Lanham Act cases. I would say when we were talking about the 80s before, in the 80s and 90s, I think Lanham Act cases were very much the route that people went in trying to stop advertising. And there's significant case law from that time period, and remains to this day as an option. The key thing in a Lanham Act context is the ability to get damages potentially for an offending conduct. So if that's of critical importance to your client with respect to somebody's advertising, but you have to look at what the claim is. Is the person denigrating your product, or is the person making a false statement about your product? Then maybe that's the route to go, maybe. Or is the person making a claim that's simply unsubstantiated, that they're saying that the performance of their product is backed, implicitly is backed by sound scientific proof, when that's not the case. Now, the Lanham Act does not afford a remedy for unsubstantiated advertising. It has to be a false representation. So you have to be able to plead that what the advertiser is doing is a false representation. So that's a key component.
So Lanham Act is really, it's only available if a competitor is citing you and your company in their ads. Is that fair to say?
No. It can be about their own product, but it has to be one that is going to be damaging you as the competitor. So sometimes, that's the question. How do you say that this damages me as a competitor? So if you're in the same marketplace, if you're both selling toothpaste, and this person says gets their teeth extra white, and you don't think it does, that can be a basis because you're selling your own version of toothpaste. But that's the question. The question is, can you show that you are going to be damaged by that act, even if they don't mention you? But the typical space is going to be a situation where you're saying one product is better than the other.
Got it. And if you feel strongly, yes, we've been damaged by the competitor's ad, is that a kind of a strong argument to pursue a Lanham Act litigation versus an NAD action?
Typically not, and a couple of reasons why. First of all, usually when you drill down to what the client wants the ad to stop, the false advertisement to stop. So the question is, how quickly can we get there? The second thing is, how important are these damages, and are you going to spend very significant amount of money with the hope of trying to collect additional funds? How much have you been damaged versus the cost and the distraction of getting there? Those are sort of the really heart-to-heart conversations that you have to have with a client in evaluating it. But there's other downsides to having a Lanham Act case, to bringing a Lanham Act case. One of which is being at risk for counterclaims. Many times, he who lives in glass houses shouldn't throw stones, and the challenger's advertising may not be as pure as driven snow as he or she thinks. And are you going to be subject to potential counterclaims and having them to defend your own turf? So that's one. And the other area that I think is of increasing concern is discovery, meaning production of emails, depositions, things like that. With electronic discovery, that ends up being a very, very significant cost of any litigation. Can be a crushing cost in litigation, given the utilization of emails and all other types of electronic communications. So those are factors that you're going to need to think about. And also the time. How long is it going to take the courts to come to a resolution? I mean, as we're recording this, we're still in the COVID pandemic. Courts are not operating at a full capacity. There are no really jury trials going on right now, and courts are very reluctant to proceed in civil litigation right now. Even outside of that, so civil litigation generally takes a backseat to criminal litigation, and so civil litigation tends to move a lot slower in the United States. So those are factors that you need to keep in mind. Ultimately, when I'm discussing a potential matter with a client, my question to them is, what's your goal? My true question at the end of the day is, what's your goal? When you get aside the getting irate about what the person is doing.
Yeah. And it sounds like a traditional Lanham Act civil litigation could be fraught with unanticipated risks and costs and delays. So maybe tell us a little bit more about the National Advertising Division option, and how would a fellow business owner like me pursue that venue? What is that experience like? Are there any risks and downsides? And what are some of the typical resolutions that come out of it?
Sure. So the NAD is a very unique body. As I mentioned before, it is self-regulatory, so it's a voluntary process. It's overseen by the Council of Better Business Bureaus, and a typical client reaction when I mention it is, well, what's the big deal? It's voluntary. I have real concerns here. I have real problems. I don't want to just file a complaint with the Better Business Bureau. I want this advertising to stop. And when they founded NAD, what they did was very, very clever. They worked out a relationship with the leading regulators, particularly the Federal Trade Commission, which is the national regulator, if you will, of the federal regulator of advertising. And they set up a referral process. And the referral process is that if someone does not participate in an NAD process or fails to follow NAD's recommendations after going through an appellate process, if they choose to, the matter is referred to the Federal Trade Commission or could be referred to the Food and Drug Administration. And the arrangement that they have is that the matter goes to the top of the pile, if you will. It is assigned to an enforcement attorney. Now, that doesn't mean that a case is going to be brought by the Federal Trade Commission, but it's going to get looked at very, very closely and very seriously. And as a result, I think the most recent statistic is there's something like a 97% compliance rate with NAD decisions.
Wow. Amazing.
But people, which is pretty amazing if you think about that. There have been very interesting instances where people have gone through the NAD process and have declined to accept the recommendations. And probably the most famous case is Palm Wonderful, which began with NAD recommendations, ended up with a major Federal Trade Commission case that went all the way to the Supreme Court, and overall did not go great for Palm. There have been other cases. Airborne, for example, was a high-profile one. Airborne was a dietary supplement that would help with your immune system support. Went through the NAD process. NAD recommended changes. They declined to do it. Ended up with a very significant FTC case. Ended up paying tens of millions of dollars in restitution and the like, and had to really change its advertising dramatically, not that dissimilarly to what NAD had recommended. So they could have avoided a lot of problems. Now, importantly, NAD does not award damages. So it's really a question of changing the advertising, right? That's a key thing. Is so if your goal is to get the person off the air or off the internet or whatnot, that's ultimately your goal, then that's what, this is a great process, given the hammer of the referral to the enforcement authorities. There's other benefits to NAD. There's no counterclaims. So when you, if you're the challenger and the advertiser pokes back at you, but challenger is doing the following things, NAD really doesn't listen. They'll say, file your own challenge on that point. So there's no risk of counterclaims. There's no discovery. So there's no production of documents. There's no production of email searches and things like that. There's no depositions. So the distractions of those other areas of litigation are really not there. And then there's sort of the intangible. When you file a matter with a federal judge, the judge is evaluating a wide spectrum of cases on a daily basis. He or she could be hearing criminal cases, could be hearing, all types of civil cases, you name it, right? Everything across the board. The hearing officers, if you will, at NAD are advertising attorneys. And so they are experts at understanding the law and the applicable standards. Where they are not experts, and lawyers aren't an expert in that area, is on the scientific aspects of it, the substantiation. And that's what really needs to get filled in with experts. But those are sort of the factors that we would discuss with a client in terms of proceeding. Now, NAD has evolved from having one track in which a matter would go through the process and typically get resolved. The time frames have varied, but say about 6 months. I think they would say 4 to 6 months. They recently initiated a fast track process in which, if you have a single issue, it's a very streamlined approach. They claim to have a decision within 20 business days. And they've also added a complex track, which can take significantly longer than even the 6 months, because the matter is quite complex. So, the time frame on it is going to very much depend on the track you take, but typically about 6 months. And I will say, most federal litigations, you're not going to be from start to finish in 6 months. No way.
Right.
It's pretty rare in terms of at least getting a decision. Now, you may resolve the matter, but at least to getting a decision.
Well, it sounds like there are some enormous benefits to using the NAD. And I want to just ask a question, in this day and age, unlike in the 70s and 80s, especially when we're talking about B2B companies and professional services firms like Roundtable Group and Olshan, we don't do commercials anymore. We do online ads. We do LinkedIn ads. We do Facebook ads. We do Google ads, AdWords. Just out of sheer curiosity, are you seeing litigations and NAD actions in that context, or is it more typically in the traditional commercial and print advertising context?
No, it certainly has evolved to e-commerce. Significant amount of disputes right now are on social media posts, and an area that a lot of brands have been using is influencers, because as you say, traditional advertising, people don't watch TV in the traditional sense like we did in the 80s when we had 8 channels or whatever.
Right.
People watch on their phones and the like, and at their own time and stream. So brands have certainly transitioned very much to social media. But similarly, NAD will look at digital advertising campaigns, blogs, and the like, YouTube videos. All of those things are fair game and have had a significant amount of rulings with respect to them. I mean, I can say with social media, NAD has really sort of been at the forefront of the disclosure requirements for influencers, way ahead of even the Federal Trade Commission in terms of it, at least in the early set. So very much continues to evolve as advertising continues to evolve.
Very good to know that NAD is highly relevant even in the modern digital era. And I guess last question I have, you mentioned experts, Andy, and the title of this podcast series is Engaging Experts. So I'm really curious about, having been at this game for as long as you have, how often are experts and expert witnesses engaged in the context of advertising disputes? Generally speaking, Lanham Act in particular, and I'm curious if experts are used in the NAD context.
Yeah, your expert is a critical component. And when I'm discussing a matter with a client, pretty much the first couple of questions that I'm going to ask is, who's going to be our expert? Who do we have who can talk about these things? It may be a survey expert if we're looking at the impression that something has on a consumer, but you're also going to need an expert to explain, particularly when it's a substantiation question. Someone's going to need to be able to either having undertaken tests or studies, or to be able to explain the scientific literature. In a Lanham Act case, an expert witness is going to be extremely important for the jury to hear. And working with your expert early on in shaping your case and in shaping your theories, whether you're on the plaintiff side or the defendant side, is going to be of great importance. In the NAD context, I think it's even more important because the hearing officers who are advertising attorneys, they are very smart and they understand the law. What they really need to know is who's right on the science and why. And it's of paramount importance that your expert, number one, be involved in the process, but when you have your hearing, that you allow your expert to explain the science and to answer their questions. In other words, if the hearing officer will ask, as they always do, questions about, what the expert's points are or what the other side's expert's points are, it's very important not that the lawyer answer those, but that you allow your expert to answer those. And the expert has to do so candidly. right? If your expert is not going to be candid and may have to make concessions, that's okay. But you want to make sure that your expert retains his or her credibility. But it's very rare that you're going to go into an NAD case without your experts and be successful. You really need to have your experts lined up, prepared, and ready to talk. And many times there's multiple experts in a case to be able to cover various subject matter that they are proficient in. But the NAD very much wants to hear from the experts, frankly, more than the lawyers, if that makes sense.
Well, these are certainly the wisest and truest words that I've heard all day. And being the self-proclaimed experts on experts here at Roundtable Group, it's obviously music to our ears that experts are called upon early and often in these kinds of matters. And of course, we've had the privilege of working with you, Andy, and many dozens of your peers over all these years on placing such experts. So thank you for that. And any final words or advice or wisdom learnings that you've had over the years regarding advertising disputes that you might want to share with our listeners, both executives and fellow lawyers that are listening to the podcast?
Yeah, I would say if you see something that your competitor is doing, it very much makes sense to reach out and call an advertising law specialist and to discuss your options and to discuss what makes sense. Too often, someone will say, "Well, I'm going to go file a complaint with the Federal Trade Commission," and just proceed with that. And that can be fine, but they should understand their options. They should understand that every option has pluses and minuses, and there is not one size fits all. But there is a way to get there. It's just a question of making sure everyone's on the same page with their goals. So don't go off without having a firm, at least idea of what you have in mind and a plan to get there. Developing substantiation takes time. And so it's important to get involved early and to map out. And don't say to yourself, well, this person's doing it and it's going to cost millions of dollars to get them to stop. That's not necessarily the case. There are options, and there are under the circumstances reasonable options that can help address the situation.
Andy, would you be graciously willing to serve as a sort of guide or coach or counselor to those of our listeners that are contemplating taking action because of false advertising claims? And if so, how would they reach you?
Sure, it'd be my great pleasure to do so. Feel free to reach out, send me an email at alustigman@olshanlaw.com, or you can call me at 212-451-2258 and be happy to discuss your concerns with you.
Thank you so much, Andy. And Lustigman, that's Lustigman. Andy, thank you so much for being on our show today. It's been an honor. Always a pleasure to hear from you. Thanks again.
Good to hear from you, Russ. Thanks.
Take care, everybody. Cheers. Bye.
Okay.
Thanks for listening to Engaging Experts. Be sure to click subscribe so you don't miss our future episodes.